Mr. Moore.
My Lords, I'm back. Just one matter. My learned friend, Mr. Pillai, who appears on behalf of HMRC, has asked me to indicate that the parties are content for the costs of the permission application to be addressed in writing. He'll obviously be making an application. And both sides are content for the costs of this appeal also to be addressed in writing.
Fine.
Consequential on your judgment. What I propose to do is just spend a couple of minutes showing you a few extracts from the rules, and then I'll make my submissions, and I'm confident I can be done in say 45 minutes. So you find the rules behind tab 22
Thank you.
of the core volume, page 240. And what you see there is some amendments to the rules, which you can ignore. And then if you go to 248, you go to the complete but unamended version. As I say, the amendments are of no material effect. And then if I invite you to turn to Rule 2 on 251, you see in familiar terms the overriding objective. You see in 2A what dealing with a case fairly and justly includes, and in 3A and B that the tribunal must seek to give effect to the overriding objective and it exercises any power under these rules or interprets any rule or practice direction. You then go to Rule 5, and 5.1 gives the tribunal power to regulate its procedure. 5.3 is without restricting the general power in 5.1, the tribunal may by direction do a whole number of things, including require a party to produce a bundle for a hearing. Just pausing there, the rule must carry with it the power to direct that the costs of preparing the bundle be borne, but it is silent on the subject of whether or not the tribunal can direct that the costs of producing the bundle be shared. You then go to...
Why must it carry with it an implication that the costs of producing the bundle be borne? That would follow automatically unless there was some contrary.
Yes, well, that's my point.
I see. So, but I mean, you couldn't make... The whole question is whether you could make a contrary provision. You don't have to make a positive provision. It's the automatic consequence of ordering someone to do something that they bear the costs, unless you can make a contrary order, in which case the question arises, can you make a contrary order? And that's the very question we're arguing about.
Indeed, indeed. I'm just showing you the rules at this stage.
Yeah, fine.
I will come on to make a positive submission. At 10, you see that at 10.1, the tribunal may only make an order in respect of costs, and then it sets out a series of circumstances, A, B, and C, none of which obtain in this appeal. So those are wasted costs, at 10B, unreasonable conduct costs, and at 10C, where the proceedings have been allocated as a complex case and the taxpayer has not opted out of the cost regime.
You say, do you really, under Rule 5.3, that you look at some of the provisions permitting a party to amend or adjourning a hearing, they carry with them the implied provision that it could do so on terms as to costs. Is that your point, effectively? I'll adjourn this, provided you agree to pay the costs of the other side.
No, because the consequences of an adjournment, there's no necessary costs of an adjournment.
No, of course there aren't. But of course there aren't. But are you saying it could do? You're saying it's inherent in 5.3 that the orders could be made on terms, or not? But you're not saying that.
Well, what I say is that the necessary functional consequence of 5.3 in respect of at least some of the directions under 5.3 is that costs be borne.
But be borne by the party
Yes,
having
quite.
the test. But the whole question is
Quite.
whether you can impose them on the other party.
Yes.
And I suppose the point about adjournment could be partly met by saying that if the other parties had acted unreasonably as caused the need for the adjournment, then 10(1)(b) would apply.
Yes, but
That would be the argument against you.
Yes, it would. That was the follow-on argument. But I suppose that in cases where you haven't acted unreasonably, nonetheless, you would say it might be surprising if the court couldn't impose a term, even though it hadn't been unreasonable. They would incur the other side in costs.
Well, imposing a term in return for an indulgence isn't, I mean, the fact that a court can do that doesn't have any larger implications for the effect of these provisions, does it?
I'm sorry, my lord, I didn't quite follow your...
Imposing a term that somebody can have an adjournment if they're prepared to pay the costs.
Yes.
Effectively, what he is doing is volunteering to pay the costs in return for an advantage. That's rather different from the jurisdiction to award costs over their dead body, so to speak.
Yes, I do take, I absolutely take and adopt that point. And indeed, in the first-tier tribunal, the judges made a very similar point in relation to the production of documents. So they were contemplating there a world in which X asked for certain documents to be produced by Y. Y said it's going to be incredibly expensive. The tribunal said, well, I hear that point. What do you say, X? And X says, well, I'm prepared to pay the costs of Y producing the documents because I think they're going to turn up something interesting. And the tribunal says, in that situation, you, Y, produce the documents, but you, X, must pay the costs of Y producing them.
So one party is getting a benefit from the order, which it's going to pay for. In this case, it could be said that ordering one party to prepare the bundles for everybody gives a benefit to the other party.
Well, and that's...
Except that they didn't impose the term.
Well, here, they directed that the costs of preparing the bundles be shared, and the
That's exactly
question is
what
a question
they
of
did.
jurisdiction, whether they're entitled to do
Yeah.
that.
But you don't accept that as an argument, as I understand it.
I don't accept as an argument...
That inherent in 5.3 is the ability to impose terms as to costs if an order is made for the benefit of one party.
Well, no, as a point of principle, that is my submission.
Yeah, well, I thought it was, yeah.
But, of course, the fact that the tribunal can direct costs under 5.3 and also under 15 and 16, which I'll show you in a minute, doesn't have as a consequence that the tribunal has carte blanche to award costs. So if to take, Sir, your Lord, your adjournment point, if I had instructed leading counsel and the other side applied for an adjournment, it would be odd if the tribunal directed that the costs of leading counsel be borne by the other side, consequential on the adjournment. That looks much more like the sort of costs shifting power that I say is regulated by Rule 10 than what I say is properly the subject of Rule 5, which are the sharing of costs necessary to get the appeal heard, including the preparation of bundles.
Yeah.
You then get to Rule 10.3, and 10.3 is, as it were, the gateway to everything else that follows in Rule 10. So at 10.3, the person making the application for an order is required to send or deliver a written application to the tribunal, and the person against whom it has proposed that the order is made, including a schedule of costs or expenses claimed. So 10.3 is drawing a distinction. It's contrasting the position of payer and receiver. And I say, as did the first tier below, that it's a provision that is plainly concerned with the shifting of costs from one to the other. The underlying principal distinction I'm going to make is between cost sharing and cost shifting, and I'll expand that point in a moment. And you see further reference after 10.3 to paying and receiving persons. But the key to understanding the machinery that Rule 10 imposes is to recognise that 10.3 is the gateway to all applications for costs under 10.1. And the gateway always contemplates a paying and a receiving person.
So what's the distinction? The distinction, your basic distinction is between cost shifting under 10 and
Cost
what?
sharing.
And under 5, what?
Cost sharing.
Cost. Well,
What do you mean by cost sharing? You can.
Well-
Does it have to be 50-50?
nope.
So you've got power to hold a hearing to consider any matter, including a case management hearing. You hold a hearing. You can decide at the end of the hearing that one party or the other party pays the whole cost of the hearing. Can you?
I say that that would not be an appropriate direction to make, because how you exercise your discretion under Rule 5 is amenable, obviously, of appeal in limited circumstances. And one of the circumstances that the first-tier tribunal has to take into account is the limited costs jurisdiction that the tribunal is given under Rule 10 for cost shifting orders. So I say that when you exercise your discretion, you have to have regard to the scheme of the rules looked at as a
I
whole.
can see that, but the basic proposition is that Rule 5 enables you to order costs, gives you jurisdiction to make any costs order you like in relation to any of the matters governed by Rule 5. But you should be careful about exercising that jurisdiction because of Rule 10. Is that the basic submission?
Yes. You then move to Rule 15. And Rule 15 extends the general powers in Rule 5. 15.1c provides, in particular, that the tribunal may give directions as to whether the parties are permitted or required to provide expert evidence, and if so, whether the parties must jointly appoint a single expert to provide such evidence. And I say that it's difficult to contemplate a world in which the tribunal directs that parties jointly instruct an expert without the tribunal having in mind, and indeed being in a position to direct, how the costs of appointing that single joint expert be shared.
But surely a joint appointment implies joint liability. You don't need any order because they jointly appoint. On the face of it, they're jointly responsible for his fees, and therefore contribution would apply if one party pays. It wouldn't be a cost thing. It
Well,
would
that is, I accept, the natural inference, but it's not the only inference.
Really?
And then at 16, at 16.2, there is another provision outside of Rule 10 that entitles the tribunal to direct that a witness attend and to make provision for that witness's necessary expenses of attendance to be paid and to state who is to pay them.
That's slightly against you, isn't it? Because there, where they mean, where it could be said that where the draftsman intends a power to pay costs or to order costs outside Rule 10, it says so.
Well, it cuts both ways. I accept that point, and I also say that my learned friend's point that Rule 10 is an exhaustive costs regime, rather, cannot be right, because there is an extension to the cost regime in
Well, it
Rule.
can be exhaustive, subject to specific exceptions, express exceptions.
Can I come on to make the positive submissions in a moment? But I do say that I accept that point. It plainly is a rule that cuts in both directions. So can I then go relatively quickly through the submissions?
Of course.
I say that first point is this is a question of statutory construction. It goes to jurisdiction, and the present facts are irrelevant. Whatever rules 2, 5 and 10 mean, they must mean the same thing. The tribunal must have the same power, whatever the facts are with which the tribunal is confronted. And my learned friend can point to some ugly features of my case, and I can point to some attractive features of my case, but I say they take the answer no further, because the answer must be invariant.
Yes, understand.
The second point is that the FT can, it is common ground, give case management directions that have as their inevitable consequence that one or both parties bear costs. And the best example of a one-party case is perhaps this case, where the tribunal can direct that X alone prepares copies of the bundles. And the best example of a two-party case is the example that my Lord Neuberger put to me a second ago of a single joint expert that carries with it the necessary implication of a sharing of the costs of the appointment of that single joint expert. The third point is there is, I say, no relevant functional difference between a direction that has as its inevitable consequence that someone bears costs and a direction to bear costs, because both have as their inevitable consequence that costs be borne. Now that's an important point, and it disposes of the policy-based arguments advanced by HMRC that the first-tier tribunal rules reflect a desire to give the parties certainty on cost exposure. The parties can't have certainty on cost exposure because they don't know what directions they may be subject to, which directions carry cost consequences. They don't know whether the tribunal is going to direct a single joint expert. They don't know whether the tribunal is going to direct a witness summons. They don't know whether the tribunal is going to direct electronic bundles. So whether I am right or the Court of Appeal is right, the parties can't have the security that my learned friend says the rules in this form exist to give somebody who is not within any of 10, 1, A, B or C. And I say that's a powerful point because it disposes of the policy-based distinction.
The whole premise of Rule 10 is that there is an element of certainty. Maybe it's not complete, but you wouldn't have an option to opt out of the complex case system if it wasn't thought that by opting out you might not get a certain benefit.
But you don't, whether you opt in or you opt out, you don't get that benefit because it is common ground that you can be subject to a direction if you've opted out of the cost regime.
They obviously think you get some benefit.
To bear all the costs.
No, you obviously get some benefit, otherwise the provision wouldn't be there at all. At least it was thought that you did, and presumably you thought when you elected out of the complex cost regime that it was going to produce some benefit.
Yes.
Right. Well, on that basis, your argument on Rule 5 introduces greater uncertainty, doesn't it? Because it means that there's greater exposure to cost orders.
Well, with respect, sir, my Lord, I don't accept that submission because at that point, because whether I opt in or opt out of the cost regime, take a standard case as a better example, where there is no possible exposure, the rules say, to a costs order. If I'm a litigant in a standard case, I can still be amenable of a direction that I bear the costs of preparing bundles. And if I have opted out of the cost regime and I'm in a complex case, I can also be amenable of a direction that I bear all of the costs of preparing the bundles. All that I am saying here is that with that risk comes the smaller risk that I can be required to share the costs of bearing the bundles. There is no protection awarded or afforded by a direction made under Rule 5 cognizant of the policy expressed by Rule 10.
Could the tribunal make an order under Rule 5 that the parties are to agree a bundle of documents and that party A is to copy and supply them on behalf of both parties?
I'm struggling to see the difference between that direction and a direction that party A prepare the bundles. Which is a direction that obviously the FTT can make.
So it sounds like an imposed agency. I'm not sure whether that was within the rule.
And of course the Court of Appeal says that the first tier tribunal, has power to direct that both parties prepare the bundles.
Yes, well, that would fall within the rule, require a party, but to require one party and then to provide that the party is to be deemed as acting as agent for both parties, possibly might be difficult.
So I say that that is a very compelling point. The fact that whatever the correct construction is of Rule 10.
I mean, I'm just looking at, I'm looking at 3I. Require a party to produce a bundle for a hearing. Now, that would be broad enough to include requiring both parties to produce a bundle or bundles for a hearing. And I'm just wondering whether there's any reason why tribunal can't give instructions about how that's to be done.
Well, that was what the Court of Appeal contemplated. But as this set of facts establishes, there are going to be circumstances where there is disagreement between the parties as to what should be included in the bundles and what costs are properly recoverable. And if you pursue that line, you still have to face up to how the tribunal deals with the world in which the parties are unable to agree. The tribunal must ultimately be able to have power to direct how the costs are to be borne. What if X says, I want 3 copies, and Y only need 3 copies, and Y says, I want 8 copies? And the parties are unable to agree how the costs of preparing the bundles be shared.
Well,
Very similar to what happened here.
It depends whether it's reasonable or not, doesn't it? I mean,
But the point is that the tribunal has to be in a position to resolve that difficulty.
Well, I'm not sure. Is there any reason why, if your instructors listeners have been so minded, I appreciate it's rather an unattractive question, they couldn't simply have said to HMRC, here's one bundle, make as many as you like.
Well,
or they
there
could
we
go to the
are
court for directions.
descending into the rules, the directions enabled those instructing me to say to the revenue, we don't agree with what you want to put in the bundle. So the bundles are not agreed, and in that world, each side has to prepare their own bundles. So there were issues around, in particular, what should go into the bundles. And the revenue wanted an awful lot to go in, which we said was unnecessary. And that was one of the factors that led to the first tier tribunal making the direction that it did.
Well, I mean, one see in the statement of facts that if your side are accurate, they proposed all sorts of ways of reducing the costs, e.g. electronic bundles or shortened bundles or reduced number of bundles, or not having to send a complete copy to a gentleman in Los Angeles, and were met by the HMRC disagreeing on every point. But that while that may generate one's sympathy with your clients,
it's irrelevant.
Can't really help on the construction of the rule, can
No,
it?
absolutely not. I don't pray it in aid. It was the very first thing I said once I'd got through the rules. I say you can't look at the precise facts in order to determine the questions of statutory construction. But the fact remains that if the Court of Appeal is right, and the first tier tribunal has the power to direct that both sides prepare the bundles and stay silent on the question how the costs of that exercise are to be shared, and the parties don't agree, forget about this case, just look at it hypothetically, the tribunal has to have jurisdiction to resolve that difficulty.
And an alternative way of looking at it is that if, as in this case, there's already been an election to go for the no-costs regime in a complex case, the duty of the court is to take that into account when deciding what burdens to impose on each side.
Yes.
It may well incline the court, for example, to spread the burden evenly on the basis that neither party is going to get the costs.
Well, I say that's not only possible; it's right in exercising.
It doesn't
its
help you
discretion.
here, does it?
Well, it does, because there's been no appeal against the exercise by the first-tier tribunal of its discretion. So it's accepted that if the tribunal below had jurisdiction, it was entitled to make the order that it did.
That's
Well,
the point.
So the only question here is a question of jurisdiction.
Yes, that is so, but the problem is that the court has not, instead of saying to itself, because neither party is paying any costs, we must divide the work of preparing the bundles equally. The court simply said, gave a direction as to who was to prepare the bundles, said nothing about costs. That's a rather different thing.
Well, it's possible to contemplate worlds in which the first-tier tribunal acts without regard to Rule 10 and without regard to the justice of the case and without regard to the consequences of a party's decision to opt out and to make directions that are odd directions which give rise to crazy consequences.
Well,
I don't deny any of
It would
that.
clearly be possible for the court to load the whole burden of the litigation onto one side in a case where there would going to be no order for costs. But I very much doubt whether, if its attention had been drawn to the implications, it would do that.
Well, this is not something this court can deal with, but your clients clearly proceeded on an understanding that the order was a valid order. Have they considered the possibility of a quantum merit claim?
There is a claim for wasted costs.
Now, that's under the
Or is it
rules.
unreasonable conduct costs? There's
But,
an extant claim for unreasonable conduct costs.
Parties clearly could make an agreement outside the scope of the rules for cost sharing, as appears they did in relation to cost of transcripts. Now,
Well, there was a direction, as it
where
happens.
one party provides services to another under a void contract, there's a pretty well recognised jurisdiction to compensate by way of quantum merit. If your clients put in documents at the request of the revenue, which they wouldn't otherwise have put in, and supplied them with all sorts of bundles, and at their request sent them to the Los Angeles, etc., under the impression that they were covered by an order, in fact made without jurisdiction, it might be thought that they'd have a valid claim of common law. Now, you may say that it's very unsatisfactory that the rules should leave a lacuna which would have to be filled in that fashion. But I just wonder whether your clients have considered that approach.
They have no.
Well,
My Lord will
So
be putting
question
in a
of-
fee note.
privilege. I've accused your lordships of making submissions. And
All right. No, I quote you. It may be an embarrassing question, so there you are.
Well,
Treat it as an aside.
This appeal is about jurisdiction.
Yes.
It's not about doing justice between the parties. It's a narrow point of jurisdiction. That's what I said to start with, and I'm content to proceed on that basis. Whether there is some remedy that, of course, I'll be citing the transcript in any claim before the council. But should I find myself in that world?
The less we say, the better, then.
Too late now. So I then go on to the question, what do the rules tell us as a matter of statutory construction? So just drawing the threads together in my brief discussion through the rules. Plainly, no explicit power to award costs of complying with directions under Rule 5. I say there is clearly an implicit power to direct that the parties bear or share the costs of complying with FT's directions. So the first-tier tribunal can direct that the parties jointly appoint a single joint expert.
Yeah, we got that.
And that carries with it the necessary consequence. I also say that it's clear that Rule 10 is not a comprehensive code for dealing with costs. You can see that from 16.2b, although I absolutely take Paul's point that that rule cuts in both directions. I say that the language of Rule 10 is the language of shifting costs from the payer to the receiver. I say that is consistent with the underlying distinction of principle that I seek to draw. And if, just pausing there, if you contemplate the regime that operates in the small claims court, where the costs of getting the appeal on, i.e. the costs of witnesses attending, the costs of issuing the case, any court fees, any lost earnings up to a statutorily prescribed amount can be recovered. Those necessary costs are subject to direction of the court. They can be claimed by the winner from the loser.
If Rule 5 is to be read as containing an implied power to make some form of costs order, how do you formulate the power which is to be read into the rule?
Well, I say that the court can, the first-tier tribunal rather, can direct that the parties comply with any case management order and can make directions as to how the costs of that case management order are to be shared.
And what does shared mean? That each must be paying a portion?
Borne or shared. So yes.
But I don't understand.
It's 100% to be borne by one party.
Well, you wouldn't need to do that. You would just direct. So if I direct that X prepares the bundles, I am directing that X bears the costs, all the costs.
Just so I can get this down.
Quite. Therefore, it is a cost-shifting order if you say X prepares the bundles, but Y has to contribute towards the cost.
Well,
It must be a cost-shifting order if, as you accept, ordering X to prepare the bundles means he pays all the costs.
Well, it's an order that the tribunal has power to make. It is an order of for the management of a case, an order necessary to get the case on, or that the first-tier tribunal regards as being appropriate to direct in order to get the case on. So I say that the FGT could not properly direct, for example, that X be represented by leading counsel. That would not be an appropriate case management order. That would be...
Rule 5 contains an implied power to order one party to pay a portion of the costs of some step ordered to be done.
Yes, properly ordered to be done. Because I take Lord Sumption's point that, of course, in exercising your jurisdiction under Rule 5, you have to have regard, you properly do have regard as a tribunal chairman or woman, to the regime that the rules read as a whole imposes.
Yeah.
So, points about adjournments and so on, I see the force of those points, but I say that they are dealt with by the question of whether it is proper for the tribunal to make such a direction. I say that if there is ambiguity here, and again I'm just drawing the threads together from the rules, you have regard to the overriding objective. And those, I say, are such points as can be drawn from the statutory language. Is there a principal distinction between cost shifting and cost sharing? Really, I've already addressed you on that point. The first tier decision says, in effect, that there is, and I can show you the references. That's at page 103, line 37. So it's the paragraph beginning the general, I beg your pardon, it's page 104.
Yes. Line.
That's page 104, line 23. I beg your pardon. Just give me a second.
Yep.
Well, the distinction seems to be not between cost shifting and cost sharing, if that is a distinction between
Bringing
costs of the appeal proceedings and costs of detailed case management matters.
Yeah.
That's a rather different distinction, and it's slightly odd that there should be power to introduce costs shifting or sharing in respect of case management, but not more widely.
Well, I say that the tribunal's power to regulate cost shifting is the subject of Rule 10, but that the tribunal has power to direct that the costs, has power to direct who bears the costs of case management directions, and it also has power to direct that the costs of case management directions be shared. The first of those two propositions is plainly right.
The court, the tribunal didn't order you to prepare the bundles, did they? Or did they?
The directions provide,
Yes.
and they were agreed directions, that we should prepare the bundles, but that if there was disagreement about the contents, each party should prepare their own.
Quite. And there was disagreement about the contents.
And there was disagreement, but that disagreement was resolved by reference to following the tribunal's direction that the costs of preparing the bundles be shared. That, as it were, took the sting out of the disagreement for both sides. But I do say again that it's not the right way to resolve the question of statutory construction. Lord, you have that point.
Well, okay.
So I say that the consequences of my learned friend's view of the world are detrimental to the proper administration of justice. And there are a few examples which I'll give you. The broad proposition is that sometimes the interests of justice will dictate that cost sharing is appropriate in the circumstances before the first tier tribunal. The first tier tribunal contemplates a situation where X asks for a disclosure direction, and I recall that I've already given you that example. That's on page 104, line 11 of the first tier tribunal decision. The first tier also contemplates that it has power to balance the interests of the parties and of justice by requiring that each side prepare its own bundles. But it observes that, and of course that must be common ground, but that is inimical to the sensible conduct of appeals before it. What about if the court wants to direct that there be electronic bundles? How does it resolve the situation as to a dispute between the parties as to how the costs of preparing those electronic bundles be prepared? What about if it wants to direct that in an evidence-heavy case there be transcripts? Does it have power to direct that X and Y share the cost, or must it direct that X prepare the transcripts on day 1 and Y on day 2? And I've already made the point that the Court of Appeal's suggested approach of directing that both sides prepare the bundles doesn't resolve the difficulty consequential upon the parties disagreeing as to what should be in the bundles, or by whom they should be prepared, or by whom they should be photocopied, which disagreements have cost consequences. Yes. If the Court of Appeal is right, the FTT must have power to resolve those issues.
Your central point is that Rule 5, in order to have full effect, has to carry with it the ability of the court to impose cost terms in order to give effect to its full powers under Rule 5.
Which are sensible and rational and necessary for the administration of justice.
Yeah.
And there's nothing in the rules
I understand.
that is inimical to that conclusion.
Yeah, I see.
And my Lord, that is absolutely my essential point.
Yeah,
and
okay.
if you read the First Tier Tribunal decision, you see that expressed as well.
Okay.
My learned friend's proposition, and this is the final point I'll make, taking me up to my 45 minutes. If the desire is to give the desire of the rules expressed in Rule 10 and the limited costs regime is to give the impecunious taxpayer protection, he doesn't get it because he can still be subject to a direction that he bears costs, the costs of complying with a case management direction. And I say there's no difference between the risk of being exposed to a direction that you bear the costs of complying and the risk of being exposed to a direction that you share the costs of complying. There is no functional difference. One is no better or worse than the other.
I haven't quite got this submission because, I mean, surely overall you are better off as a result of your election because
In the event that's turned out.
in the event you turn out, because you would have had to pay the whole of the costs of the...
Yes. Yes, that's absolutely so in my case.
Yeah.
But I say that you can't resolve a question of statutory interpretation by looking at what happened in this case. You have to answer the question in the abstract.
Well, what I'm not entirely clear about is that whether they say the cost should be shared, whether that was subject to any final order the court makes. Now, in this case, the court couldn't make a final order because of the opt-out under 10.3 or 10.1c.
Well,
Yeah, but otherwise it might have been able to.
I'm sorry, my lord. I'm
Well,
not following your point.
if there hadn't been the opt-out
Yes.
and you'd lost, the court could have said, well, even if they're liable on your basis to pay half, they can get that back under the final cost order.
Yes.
But so you say it would get washed out if there'd been the normal power to award costs, but because of the opt-out, there isn't.
Yes.
Yeah, sorry, I haven't
Yes.
put it very well.
That's absolutely what
Yeah,
I
okay,
said.
thank you.
And my lords, those are my submissions.
Good, thank you very much indeed. Ms. Balmer. Mr. Pillai.
My Lords, I propose to respond by dealing with three broad categories. First, I'm going to deal with the rules. Secondly, to talk a little bit about the policy. And then finally, to pick up on the way in which Mr. Moore has advanced the case, including in relation to Rule 16. Your Lordships already have the point that the powers to order costs come under the TCEA, Section 29.
Yes.
And that's set out in the Court of Appeal judgment. And Rule 10 is the only rule in which a power to order costs is dealt with expressly in the first-tier tribunal rules. And the fundamental misconception here in Mr. Morm's approach is to assume the existence in Rule 5 of this power to somehow order costs as a substantive adjunct to the power to make directions. Now, we say that Rule 10 is comprehensive, not only because of its opening wording, and if your Lordships have that to hand, but will probably recall it, it says that the tribunal at 10.1 may only make an order in respect of costs under the situations that follow in A, B, and C. And an application can be made for costs or an order in respect of costs at any time during the proceedings. So it's not the case that there is any sort of real distinction, as Mr. Morm has tried to set out, and as your Lordships were dealing with towards the end of his submissions, about costs of case management directions as opposed to costs at the end of the hearing.
So you say the strict restrictions under 10.1a and 10.1b apply to the court's powers to award costs when making an order under Rule 5.
My Lord, yes.
In effect, they can only impose terms as to costs if wasted costs or unreasonable behaviour.
In this case.
Yeah, because of the opt-out.
Because of the opt-out,
Yeah,
but
okay.
otherwise,
Understand.
So if there was an interlocutory application, in a case where there'd been an opt-out, but the interlocutory application was regarded as being a complete waste of everybody's time, then the tribunal would have power under Rule 10 to order the costs of that hearing to be borne by the
if there's
unsuccessful party.
if there's been an opt-out,
Yeah.
then you can only order costs if there's been unreasonable behaviour or wasted costs. So if the interlocutory application was a complete waste of time,
Yeah.
then such that it was unreasonable behaviour, then unreasonable to have brought it,
Yeah.
then you could order costs. But otherwise, and this is the point where we're talking about certainty, and my Lord Mance raised it, the benefit to someone in Eclipse's position, for example, could be they could have brought a weak application, but one that fell short of being unreasonable.
Yeah.
Lose the application and still walk away only being liable for their own costs, because the fundamental policy application here is that you say early on the taxpayer can say, do you know what, I'm happy to bear my own costs of taking this as far as I can, but I'm not going to be on the hook for HMRC's costs.
I understand. If the court wanted to say you share the preparation of the bundle, cost of preparation of the bundles, could it have made an order on your case which had that effect?
It could have made an order which would have meant, yes.
What would the order be?
It would have been that the parties jointly prepare the bundles, and the Court of Appeal dealt with that.
So once there's joint responsibility, then it follows that there's joint liability for the cost.
Absolutely.
Okay, fine.
And that, just for the reference, is paragraph 22.
Yeah, well, if we agree with everything the Court of Appeal says, well, we haven't got much point. But if that's your submission, that's more important. Thank you.
Well, it is, but I think it goes further than that, and that's why I urge your lordships to consider that reasoning, because the fiction here is that the first tier could not then deal with problems in the management of that
That's why I asked.
arrangement.
You say it could.
We say it could because it's always got the position of saying you're behaving unreasonably, and my learned friend's side, or whichever party, can say, write to the court and say, look, they're not agreeing this, they're being unreasonable for these three reasons. Please either make a direction requiring them to do X or order costs against them. That would be an order dealing in a case management context, not at the end of an appeal, dealing with their costs. So, my Lord, that, we say, deals with the position that there is no...
I'm sorry to interrupt you, but is there any possibility of an appellate court substituting an order which would be within the jurisdiction of the tribunal?
Retrospectively.
An appellate court.
Us.
I appreciate that.
Which the tribunal would have made if only it had been better informed about its jurisdiction.
My Lord, I would say no in these circumstances. It's not the order that it's not the relief that's being sought here.
Yes.
And it may be that there might have been a different form of wording that might have been appropriate, but
It'd have to be some sort of rather
Have to be a
appeal
rectification.
or something.
Have to be a sort of rectification.
Yes.
My Lord, yes, and here...
We can't make an order requiring the parties to prepare joint bundles when the bundles jointly prepare bundles when the bundles have been prepared 4 years ago. Plus.
My Lord, no. But
Maybe we can do anything, but I would have thought that was pushing it.
Or we could backdate our order.
we might notice, yes. Question of HMRC and retrospective action, my Lord, I don't think I can assist you further with that. But so, my Lord, we say
But
that...
it could be said that this is a triumph of form over substance, particularly in the background of, it could be said that one wants to try and construe the order so that it's effective rather than ineffective. That must be a principle. We have the fact, we've heard a minute ago, that the order originally said the appellant was to produce a bundle, the taxpayer was to produce bundles, but if the parties couldn't agree the contents, they were to produce bundles. you then get the order they were to share the cost, might it be said that a fair reading of that, in order to make it effective, was that the court was really saying you're both responsible for producing the bundles, because that would mean there was an effective order rather than an ineffective order?
My lord, the direction was made orally, and
It was.
on the facts
I was
of this
looking at
case.
it.
In
On
my
the
submission-
electronic page 202. We think that the cost should be shared, and we will direct accordingly.
My lord, yes, but exactly so on page.
In,
page eight.
in my bundle,
Yes,
page,
that's-
the order appears to be removed, but it's page 1545146. But for some reason, it seems to be excluded from my bundle. Anyway,
No.
might it not be said that they were really saying, well, you're both liable for it because you can't agree, and therefore you're going to share the costs?
Well, my lord, I don't think that would be the fair reading, because the actual order is at page 205, and we've been sort of floating around it, but it's at paragraph 13 on page 205 of this bundle, which says that the parties shall endeavour to agree an indexed and paginated bundle, 13, and then little a, which is, in effect, it sounded to me like the order that my Lord Toulson was suggesting, which is that the parties agree the bundle, and then the hearing bundle is to be prepared by the appellant. And that's what was agreed and then encapsulated
Yes, I see. Thank you.
in that direction. So, my Lord, I'd say that I don't think it's a triumph of form over substance in circumstances where the original order is as recorded, and then the direction made is that the costs be shared. Because going back to the point that...
Is this...
Sorry, my lord.
Is this before or after page 202, the discussion where the costs were to be shared? This
So,
is...
The order was before the
Yes.
that
yes, so
discussion.
page 205 is before
202, of course.
202.
Wouldn't be a proper bundle if it wasn't. Yeah.
Yes, I see. Did you it come back at a separate occasion? Or-
It had come back at... your lordship was looking at 201 and 202 as a
Yeah.
transcript. It came back at a case management hearing where the main issue was about...
Yeah, I see.
You say the trouble with my interpretation is that 13b envisaged each party preparing separate bundles, and that wasn't envisaged by the court order, the oral court order. Yeah. Okay.
No, the oral court order
enough.
is envisaging
A single.
the agreed single set of bundles.
So it was to 13a, not to 13b. Understand?
My lord, yes. And so where we come to, and in essence is not controversial, is back to where my Lord Assumption intervened, in really saying that, well, you've got a power to give directions, and you need to be mindful of the cost consequences of such directions as you make. And the context to all of this is a tribunal system, and it's in my written case, and I'll come back to it, but which is essentially a no-cost regime, save in the express circumstances in which orders for costs may be made, and that is governed by Rule 10. And part of the reason why what my learned friend suggests is actually unworkable is because of the manner in which the discussion ranged this afternoon. Because what my learned friend was saying, and I couldn't quite understand where the borders are to be drawn, but is that some of the directions in Rule 5, and obviously Rule 5 is not an exhaustive list, but some of those directions were not susceptible to a costs order, because it might amount to cost shifting, or you couldn't order that the costs of the other side's QC should be paid, or you could have a direction, or the power could be articulated that the cost might be borne or shared, but then there could be 100%.
One of the problems is, it seems to me, is that 3 is merely a specific list. 5.3 is a list, but actually 1 and 2 are the general provision. 3 are just for the avoidance of doubt. So the court could make any order that it thinks appropriate. And that would almost undermine Rule 10, you can say.
There would be no way And of course, there is the point that Rule 5 contains no mechanism for dealing with costs, including assessment and ability to pay, which is all set out in Rule 10, and that's crucial. I don't need to take the court through those, but it's set out there in relation to making the application, but also, for example, 10.5, about not making an order against the paying person without giving an opportunity to make representations or considering financial means. And then you've got provisions about assessment. Now, these are all familiar to anyone dealing with costs, but there's no such mechanism in Rule 5. And just to pick up on the need to make orders that properly reflect the overriding objective and the no-cost regime, the answer to things like electronic bundles and also to joint experts and transcript costs is that the tribunal must only order those if it would be appropriate so to do in the instant case. And that is the exercise of evaluation and judgment that a tribunal and a court must always be carrying out with the overriding objective in mind. And it's an entirely separate point where parties have voluntarily agreed to bear costs. In this case, the agreed directions reflects the fact that the parties had agreed to share the cost of the transcript. And that was at page 206 of the bundle. And it might be that a party might buy the indulgence of the court by way of an adjournment by agreeing to pay costs. But it's a separate question, and one that would be impermissible for a direction to be made as to cost sharing under Rule 5, because only Rule 10 could be exercised in that way. So well, that essentially is my submission as to why the direction here was made out with jurisdiction. As to policy, my Lords, I've dealt with it in my case, but the particular point in relation to the tribunals not being a no-cost regime is set out by way of background in the costs report, which is at the back of the bundle, and I could just refer your Lordships to page 272 of the bundle, and paragraphs 9 and 10 set out some background.
Yeah.
That, I don't think I need to read that out.
No.
Equally, there is some guidance in the decision of Atlantic Electronics, and Mr. Justice Warren's approach on policy in that case has not been doubted. It was adopted by Judge Berner in the Upper Tribunal at paragraphs 22 to 24. And the Court of Appeal also referred to it at 7. And in that case, Judge Berner explains both the purpose of certainty for the early election in a complex case for an opt-out, and also that the taxpayer is not entitled to just wait and see how things are going. So, my Lord, in those circumstances, the conclusion must be that Rule 10, its terms and its restrictions in relation to costs, are deemed to be fair and just. And so there's no reason for this court to doubt those policy considerations, and those should in fact be endorsed. And as I've said, there is no limit on the tribunal's power by reason of unreasonable conduct or wasted cost orders for it to police itself. One point very shortly, there is no relevant issue here about the practice in other tribunals.
No.
Permission was obtained by reference to that, but that point just simply hasn't been advanced.
No, we're concerned with the construction of these rules.
Yeah, so I'm not going to take that further.
Well, very realistic of Mr. Morm not to. But he referred briefly to small claims, but I don't think.
No, my Lord.
We didn't look at the rules anyway. We have to construe these rules. Yep.
I'm grateful. As to Rule 16.2b, that's a slightly opportunistic point because that is a rule that deals with the payment of a non-party witness's expenses of attendance. And frankly, to latch onto the word expenses, taking it out of context, doesn't assist my learned friend. Okay. The context for payment of expenses of a witness attending is not in an adversarial context at all. It's purely a reimbursement. It's what's well established as conduct money, and there is some guidance as to what that is at CPR 34.7.1. I'm not going to take the court to it, but it's a long-established requirement, and the point being that a witness can decline to attend or be sworn until he's paid his expenses of turning up, and so you can't punish them for not coming unless they've been paid.
I'm not sure for my part whether you need to worry about this particular rule.
Well, if I could just finish on it by saying, in any event, as my Lord Newberger said, that does show that there's an express provision if there is to be some sort of payment. But it's not a point that goes both ways. It simply just doesn't go in learned friend's favour. So, well, with that in mind, if I could just wrap up as to Mr. Morm's 3 propositions as advanced in his case. The first point is that the correct analysis is based on the rules, and the rules are clear. There has to be an express power. That's only in Rule 10. There's nothing in 5. And so therefore, as to his second ground, it's entirely misconceived to contend that there is any implicit power in Rule 5. It's entirely unworkable. And what it means is that in these no-cost regimes, Mr. Morm's right, then a tribunal would have a power, effectively by the back door, to shift costs or to share costs or by way of order in circumstances where the regime is expressly a no-costs regime. And as to the third point, the tribunal is well capable of regulating its own procedure by reference to Rule 10. Unless I can assist your lordships further, those are my submissions.
Can I just understand, the actual order, I think Mr. Morm was accepting, but I may be wrong, that this was not a final order forever.
Now, the actual order, my lord, is...
i.e. that it was only a temporary order pending... Am I wrong about that? Because logically, if I'm right about that, then...
I think what he was accepting was that if this hadn't been an opt-out case,
Yes.
then they were going to share the costs.
Yeah.
Yes.
But
but-
if the tribunal had made a final order against the taxpayer, then they would have got the money back.
Well, that's the incongruity of this situation, but
Well,
again,
fine.
that's the facts of this case.
Yeah.
To that extent, it's a temporary thing.
No, I do see that, yeah.
I'm grateful.
Thank you very much indeed. Mr. Moore.
A few very brief points. Just dealing with the other rules of other tribunal chambers. As I said in my application for admission, save for the rules of the Employment Tribunal, those other rules are exactly the same. Rightly or wrongly, I took the view that this hearing was going to be advanced by my showing you multiple copies. If that was wrong, then
Rightly,
I apologise.
rightly, I think.
That was the view that I took.
If they mean what they mean, whether they're in one set of tribunals or every tribunal.
But again, and so I hope it isn't remiss of me not to have shown them.
No, on the contrary, if I may say so.
My learned friend says that if there is no, if Rule 10 doesn't impose the limit that he says it imposes, the court can effectively cause the party to bear any costs through its case management powers under Rule 5. But the problem with that submission is that it takes him too far, because if the tribunal has power to make that particular case management direction under Rule 5, it is effectively exercising power to direct that the subject of that direction bear the costs of complying with it. So I don't see where that point takes him, and perhaps I can deal with it by way of response to your lordship's questions as elegantly as I might. But that was essentially the point that I was making in response to questions about adjournments and so on. My learned friend said that the first-tier tribunal had no ability to make an order for the assessment of costs. In fact, there is no machinery in the rules, I accept that, for the making, for the tribunal to resolve questions of assessment. But there is power under Rule 27 sub 2 of the Tribunal Courts Enforcement Act. Rule 27, I beg your pardon, Section 27, excludes the tribunal's power.
Which page is that?
Let me just find the legislation. It's at Rule 29 at page 368 of the Authorities Bundle. So 29.2 says the relevant tribunal shall have full power to determine by whom and to what extent the costs are to be paid. 29.3 says that 2 is subject to the tribunal procedure rules. The tribunal procedure rules obviously contain machinery for dealing with the resolution of disputes around costs that are subject to Rule 10, but don't necessarily exclude. The tribunal rules don't deal with any power that the tribunal may have to direct that costs be shared under Rule 5. And I accept my learned friend's point about the machinery tending to indicate that he was right. Obviously, this is not a situation that the draftsman has contemplated. I say that a tribunal does have residual power under section 29.2, and it would no doubt exercise it in a way analogous to the power contained in Rule 10.3 and following.
Yeah.
And finally, Warren and Atlantic Electronics. The remarks of Mr. Justice Warren and Atlantic Electronics are what they are. They don't actually deal with this situation. They're overture. He wasn't addressed on this point. And so I say you can take nothing helpful from those remarks. You see the regime, it's in the rules, and Atlantic Electronics on the House adds nothing. My Lords, unless there's anything further.
Thank you very much indeed. We're very grateful to you both for, all of you, for dealing with this matter expeditiously. We're also grateful for your written cases. We will let you know our decision in due course. Thank you very much indeed. The court is now adjourned.